and welcome to Crimes Through Time, a weekly snapshot of crime history. This case is a significant one in English common law history. It explores the morality, ethics and legality of killing another to increase your chances of survival. It set the precedent that necessity is not a defence for murder. It concerns the death of Richard Parker, a 17-year-old cabin boy on the English yacht the Mignonette in 1884. Richard was killed by his captain, Thomas Dudley, after the yacht was shipwrecked. Out of food and fresh water, it was clear, at least to the crew, that drastic action was needed to keep them alive. The young cabin boy was already sick. He was selected to make the ultimate sacrifice. The crewmates then consumed his body to sustain them until help arrived. Their defence was based on one of purported jurisdiction, that it is a custom of the sea. The authorities disagreed. So let's look into this groundbreaking case and its curious link to Monty Python. John Henry Went was an Australian lawyer. He bought the English yacht the Mignonette in 1883. At the time, the only way to get a 53 feet, 16 metre cruiser to Australia was to sail it there, and it took him quite some time to get a crew to agree to make the 15,000 mile or 24,000 kilometre trip. Finally, Thomas Dudley was commissioned as captain, and he and his crew of 3, Edwin Stephens, Edmund Brooks and Richard Parker, set sail from Southampton bound for Sydney on the 19th of May 1884. All was well until the 5th of July. Thomas decided, as they were making good progress, to give the order to heave to. This reduces a yacht's speed and fixes both the helm and sail positions, meaning it doesn't need to be steered, allowing the crew to have a well-earned full night's sleep. However, shortly after the manoeuvre was completed, a wave hit the yacht, washing away the bulwark. The yacht was sinking. Thomas ordered the launch of the 13-foot or 4-metre lifeboat. It took just 5 minutes for the Mignonette to disappear beneath the waves. All 4 men made it aboard the lifeboat, but saved only some navigational equipment and 2 tins of turnips. The sinking of the Mignonette is a mystery of its own. There must have been some sort of structural or design issue for a yacht to suffer such a catastrophic fate under normal weather conditions. They managed to fashion a sea anchor, allowing the lifeboat to maintain some stability, and it is said the first night they had to fight off a shark using only their oars. The lifeboat was 700 miles or 1,100 kilometres from land. Thomas began to ration the food from the beginning. 5 pieces of turnip were issued to each man for 2 days. On the 9th of July, Edmund spotted a turtle, which the men were able to haul into the boat. This, along with the second tin of turnips, sustained them until the 17th of July. The problem they hadn't solved was the supply of fresh water. Drinking seawater would have been fatal. They hadn't been able to catch any rainwater. As a last resort, they began to drink their urine. It was the 20th of July that Richard first began to get sick, most likely from drinking seawater out of desperation. Edwin was also showing signs of illness. Now was the first time that the men began to talk about the prospect of a sacrificial victim. It was a heated debate. This was not a decision that these men came to lightly. Around the 23rd or 24th of July, Richard slipped into a coma. Thomas argued that it was better that one die and the others survive than them all perishing. The idea of lots was put forward, but Edmund refused. Later that evening, Thomas approached Edwin and reminded him that they had wives and children depending on them. It was clear that Richard was going to die anyway. I wondered why they wouldn't have waited for him to die naturally, but the toxins and processes that are present during a natural death would have made him harmful to consume. The next morning, Thomas said a prayer for Richard before cutting his jugular vein. Edwin held the boy's legs in case he struggled, but he did not resist. Edmund did not participate in the killing, but neither did he dissent when it became clear what the men were about to do. This will be an important point when this goes to court. The 3 men consumed Richard's body and even managed to catch some rainwater. Thomas would later say of these days, quote, I can assure you I shall never forget the sight of my two unfortunate companions over the ghastly meal. We were all like mad wolves. Who should get the most, and for men of fathers of children to commit such a deed, we could not have had our right reason." End quote. Thomas, Edmund and Edwin were rescued on the 29th of July by a German sailing boat. They arrived back to Falmouth, Cornwall on the 6th of September. As required by law under the Merchant Shipping Act, when a ship is lost, the men attended the customs house and Thomas and Edwin gave full and honest official statements. They firmly believed that they were covered by the customs of the sea. Unfortunately, Sergeant Laverty heard the depositions. He questioned Thomas and took custody of the knife. The statements were sent to several governing bodies, each giving conflicting advice. The Home Office was informed, but it was a weekend and no decision was quickly available. Laverty had taken it upon himself to get warrants for the men's arrest, for charges of murder on the high seas. He was successful and the warrants were granted by the Mayor of Falmouth, Henry Lidicott. They were detained until the morning to appear at the magistrates on Monday the 8th of September. More confusion followed and they were returned to the cells until the 11th. During this time, the Home Secretary, Sir William Harcourt, looked into the case. He consulted Attorney General Sir Henry James and Solicitor General Sir Farrar Herschel. They made the decision to prosecute, not because of the merits of the case, but because they saw an opportunity to clarify the law on the defence of necessity against a charge of murder. The Criminal Law Commissioners had tried several times over the last 80 years to clarify the law, with the last attempt being in 1879, when codifying the defence was declined, deciding it was, quote, "better to leave such questions to be dealt with when, if ever, they arise in practice, by applying the principles of law to the circumstances of the particular case." End quote. At the magistrates' hearing on the 11th, it became clear that public opinion was firmly on the side of the survivors. Richard's brother, Daniel, who was also a seaman, shook the hands of all the men. The case was also a weak one. The only witnesses were the defendants. They had the right to remain silent, which was no doubt what they would do, and the depositions were brief and not enough to give a murder conviction. To counteract this, the magistrates only committed Thomas and Edwin to trial. Charges were dropped against Edmund, leaving him free to be a witness against the other two men. Trial was set for the winter sessions of the Cornwall and Devon Assizes in Exeter. To appease the crowd, the men were granted bail. The trial opened on the 3rd of November. Judge Baron Huddleston presided, Arthur Charles QC for the prosecution, and Arthur J.H. Collins for defence. Both Thomas and Edwin pled not guilty to murder. The trial was a foregone conclusion. Judge Huddleston had already decided that the verdict was guilty in order to once and for all settle the law on the necessity defence. He planned to instruct the jury to return a special verdict. This would give the judge the power to decide guilt or innocence of the defendant. It used to be a common occurrence in English courts, but a special verdict hadn't been returned since 1785, almost 100 years before this case. In fact, these instructions were already written. Collins tried his best to present a defence. Edmund took to the stand and gave a vivid account of the actions of his former crewmates and stressed that he was not involved. But on cross, Collins did manage to get him to admit some important facts. The lifeboat was in bad condition, that he had engaged in some cannibalism, and that without doing so he believed he would have died. None of that matters though. During his closing speech, the judge presented his special verdict to the jury. He proceeded to read out each paragraph in turn. Each jury member was to agree with the content, although silence was also a sign of assent. The final words of the verdict stated, quote, "But whether upon the whole matter the prisoners were and are guilty of murder, the jury ignorant and refer to the court." End quote. He then renewed the bail conditions and adjourned the case to the Royal Courts of Justice in London on November the 25th. In his haste, Judge Huddleston had made two fatal errors. The mignonette was registered in England, so the court has jurisdiction, but he described the lifeboat as an open boat, but didn't assert that it came from the mignonette, leaving jurisdiction in question. His solution? He just altered the record of the verdict. The second became obvious when the court reconvened in London. The court could only sit post-conviction, but there had been no conviction in Exeter because Judge Huddleston intervened during the closing statement. To remedy this, the Attorney General decided a Queen's Bench Divisional Court would be convened on the 4th of December. 3 judges would preside. Collins again was in defence of Thomas and Edwin, but his submissions were limited by Lord Coleridge to only those regarding the charge of murder, meaning that the alternative charge of manslaughter could not be considered. Just minutes after Collins concluded, the judges returned, stating, quote, "We are all of the opinion that the conviction should be affirmed, but we will put our reasons in writing and give them on Saturday next." End quote. They remanded the men to Holloway Prison and set the date of the 9th of December to deliver the sentence. The panel of judges found that there was no common law defence of necessity to the charge of murder, not from legal precedent or using ethics and morality. They also questioned who would be qualified to make the decision over who should live or die, concluding the law, if allowed, would provide, quote, "a legal cloak for unbridled passion and atrocious crime," end quote. As they were convicted of murder, Thomas and Edwin were given the statutory death penalty, but there was a recommendation for mercy. The public had followed the case with interest and were outraged by the verdict and sentence. They questioned the legal process. It left the Attorney General and Solicitor General in a strange position. Anything less than a life sentence for murder would mock the law, but a sentence that harsh could not calm the public upset. There was one last twist from the Exeter trial. The jury had indicated that they would have returned a verdict of guilty of manslaughter, an option denied at the Queen's Bench. The Home Secretary, Sir William Harcourt, decided on the 12th of December that a sentence of 6 months should be imposed. Thomas and Edwin maintained that they had no other choice and were thoroughly annoyed at having to spend so long in prison. This case would provide the inspiration for a Monty Python sketch. The cast are shipwrecked and decide cannibalism is the only way. Once the decision is made, a waitress appears to take their order, including their choice of side dishes. But a much more unsettling coincidence is found in Edgar Allan Poe's novel The Narrative of Arthur Gordon Pym of Nantucket, published in 1838. It tells of a shipwreck crew that draw lots to decide on a sacrificial victim. The loser of the draw is the sailor who suggested it. His name is Richard Parker. Thank you for listening. Please like and subscribe and let me know what you think of this case in the comments below, and I look forward to welcoming you in the next one.